Well, first of all, if you're getting calls from compliance, part of the reason that's the right time to call a lawyer like me is because, we don't have to tell the firm that you're being represented, but, I can certainly coach you and go through and sort of script out what you should say and what you shouldn't say on these calls with compliance, from behind the scenes.
Hey everyone, thank you so much for joining the podcast today. Today's topic we're going to be talking about, it's not necessarily a fun one, but definitely a necessary one. It's probably one of an advisor's worst nightmares, and it's suddenly being fired, or as we call it in the industry, being terminated. More frequently every year, personally, I'm having more conversations with advisors that have been loyal to their firm for years, felt like they were doing all the right things for their clients, and are suddenly asked to leave their firm for something 10 years ago probably would have been a slap on the wrist. And this leads them to scrambling to find a new broker dealer or RIA quickly, typically in 30 days or less, protect their reputation, and also just scramble to keep their clients. This podcast isn't by any means to scare you, but basically to prepare you a parachute pack in case the unthinkable happens, number one, and then just to share some best practices if in fact something like this happens to ensure the best possible outcome. On today's podcast, we have the attorney Scott Matasar of Matasar Jacobs. There is a leading law firm that represents financial advisors and has been on the podcast before and provided massive value. Scott, I really appreciate you hopping on today.
Happy to share time with you on this, Corey. It's a really important topic.
Yeah, thank you so much for hopping on. Before we get started, Scott, why don't you just tell us a little bit about your firm and kind of how the different ways that you help financial advisors?
Sure, sure. Well, so my firm is focused almost exclusively on representing clients in the retail financial services industry. So our client base is entirely broker dealers, RIA firms, small standalone independent advisory firms, and individual advisors. And we work in several different silos. We represent clients when they are sued by customers on suitability cases. We handle intra-industry disputes, whether it's a wrongful termination or a U5 expungement or a nasty practice breakup where people are fighting over clients and suing each other over, non-solicits and non-competes. We do a lot of work representing advisors who get in trouble with FINRA or the SEC or state securities regulators, and I'm sure we'll talk about that a little bit today. On a happier note, we also do a lot of work sort of helping people run their business. We do a lot of work in drafting employment agreements if a team is bringing a junior advisor on, and to spell out the terms and conditions of that employment and to protect the existing book from being stolen by that advisor if they break up later on. And we also do a robust work in drafting employment agreements. I'm sorry, with contingency succession agreements where an advisor is selling their practice to a junior advisor, or the junior advisor is buying the practice. And I do about a dozen or 15 practice sales every year. And then the last sleeve is advisor transition work. I do anywhere upwards of 250 to 300 advisor transition projects every year. Some of those are solo advisors, some of those are teams, and they're all over the country.
Thank you. Thank you for the overview. I appreciate it. So just as an estimate, how many financial advisors do you think you've helped that have reached out to you and said, Scott, I've been terminated. I need some help. How many of those advisors do you think you've represented?
Hard to estimate, but what I can tell you is on an annual basis, probably 15 or 20 every year.
Okay.
And I've been doing this for more than 20 years now, so you get a sense of the volume.
Yeah, for sure. So I see it on my side, and I talked about in the intro of the podcast, it seems like more and more financial advisors every year are coming to me in a panic and saying, Corey, I need to find a new home fast. This is what happened. Can you just tell the advisors on this podcast, like what are you seeing out there?
Sure. I agree with your opening comments that I am increasingly seeing advisors who are being terminated or in danger of being terminated for things that a decade ago would not have even passed, muster. They wouldn't have cared. The firms would have been a non-issue. And I would say generally, what I see is advisors coming to me either because they've now had a visit and an interview where they've been locked in a room for a few hours with some compliance person and being told that they're under internal review, or they're coming to me because they have already been terminated. And I would say the advisors I deal with sort of fall into two buckets. Now, the first is advisors who have committed some sort of misconduct of some sort, whether it's a sales practice issue or whether it's a personal conduct issue. And I get both of those, whether it's somebody who and I'll break that down further on the sales practice issues. The difference between sort of cutting corners and just trying to do things fast and loose versus someone who's actually engaged in what I would consider true misconduct. So, for example, I'll get 2 or 3 advisors a year who will make a phone call to a product sponsor impersonating their client in order to effectuate some sort of a change with their product because their client has said, I'm not going to sit on hold with customer service for 90 minutes. You do it. So, the advisor, because they don't want to upset their client, goes and does that. And there's no harm. The client knows that the advisor is doing this. They've specifically told them to do it. But then, Jackson National or AXA or Equitable calls their firm and says, we think your advisor was impersonating their client. And they wind up getting terminated, not because they meant any harm, but because they were just accommodating the client. And then you get the other angle, which is the personal conduct issue. Somebody says an off-color joke or is accused of sexual harassment by a branch office administrator who's just trying to get rid of them, retaliatory, and those kinds of things. So that's sort of the first realm of people I see that need help, where they've actually engaged in some sort of misconduct. And then the other is what I would call is sort of just the firm's gotten uncomfortable. They can't put their finger on it. The advisor hasn't actually done anything wrong specifically, but for one reason or another, the firm has decided that the advisor is a compliance risk or an employment risk and wants them gone, fairly or not.
Okay. Yeah, that makes a ton of sense. And I mean,
Yeah.
I've even seen it, more benign than that. I mean, I think me and you worked on a financial advisor together. His brother passed away, 5 years ago. And every year, him and his other brother went out, to commiserate and have a beer. And this financial advisor wound up having a beer at lunch. And his branch manager saw him having a beer at lunch. And this $1 million producer, overnight,
Right.
is scrambling to find a new home and protect his reputation, like we were talking about before. So I think a lot of financial advisors, when I talk about these types of things with them, they say, Corey, I'm doing the right things for my clients all the time. I have nothing to worry about. And that's probably true, but that doesn't mean that you shouldn't be prepared and have an insurance policy just in case it does, because I see it all the time.
I tell people all the time, there's no such thing as just a friendly chat with compliance, right? If you get a call from any sort of an internal investigator or any sort of a compliance person asking questions about something, whether it's the way you're running your business or your personal conduct, in my opinion, that is the time to contact counsel. Not when you're getting, marched out of the office at 8:30 in the morning, the minute you walk in the door one day and being told that your key card's been deactivated and today's your last day. If, as a general rule, if you've got a little warning bell in the back of your mind saying something doesn't seem right here, you're probably right. And ignoring the problem isn't going to make it go away.
Yeah, and I speak with a lot of financial advisors as well. They don't know if they're getting, let go yet, and they're in that exact situation that you're mentioning. And the other people on the other side of the phone, the compliance people at their firm, they seem like they're being really friendly. They seem like they're being cooperative, and they could potentially be putting themselves in a pretty, damaging situation. I see a lot of financial advisors that I'll let you talk about it a little bit more, like what happens
Yeah.
after you get terminated. But there's something that comes out called, U5 language,
Right.
which is going to be really, really important to which firms will accept you and which ones won't down the road. But a lot of financial advisors just feel like they have relationships inside of a firm. They may want to take care of them things themselves. And just like representing yourself in court, not necessarily the best idea. Can you just talk about that?
Yeah. Well, first of all, if you're getting calls from compliance, part of the reason that's the right time to call a lawyer like me is because, we don't have to tell the firm that you're being represented, but, I can certainly coach you and go through and sort of script out what you should say and what you shouldn't say on these calls with compliance, from behind the scenes. So there's a lot of value to be added there in helping advisors perform and defend themselves when they're getting these calls from compliance, because it's much harder for me to help if they've gone and sort of handled those calls by themselves and they've made all kinds of potentially damaging admissions that they didn't realize were damaging, but now the cat's out of the bag. So there's a lot of value there that I can put in on the front end in coaching people through those calls with compliance before they occur. As far as the U5 issue, Corey, right, I do a lot of work where I am representing advisors after they've been terminated. And firms, as I'm sure advisors know, have up to 30 days to file a Form U5 after there's been a termination. And if you've been terminated, or if you are allowed, if you're permitted to resign, is another designation on the U5. Anything other than a purely voluntary separation, firms are required by FINRA to put an explanation as to why the advisor has been separated from service. And depending on the firm, I am often able to get involved and interface with the legal department at the BD and negotiate what the language is going to say on that termination explanation. Firms aren't going to lie. They're not going to sit there and mark you voluntary if they actually fired you. And they're not going to put something completely false on the U5, but there are a lot of different ways to say the same thing as to why an advisor has been terminated, which can be more or less harmful depending on how specific they are, and may or may not, depending on how they're worded, draw the attention of FINRA. And it's also not just the termination explanation, but it's also the other designations about whether or not somebody was terminated. The dreaded box on the U5 is 7F1. Was the advisor terminated for fraud, violation of industry rules or conduct, or other forms of dishonest acts, right? If 7F1 is checked, your one is almost certainly going to get investigated by FINRA after you're terminated. And I've had a number of situations where I get into heated debates with the internal personnel in the legal department about, for example, right, your guy who had a beer at lunch in violation of firm policy, right? That was a violation. That was a violation of firm standards of conduct because the firm's policy says no drinking on the job. But I would argue vigorously against marking 7F1 yes there, because it has nothing to do with how the advisor conducts their business.
Mm-hmm.
So I get into those debates a lot to try, not just with the termination explanation, but the other boxes that have to be checked on the U5 to try to minimize the harm that's caused to the advisor and the difficulty that the advisor is going to have in finding new employment.
Yeah, for sure. I mean, I've seen it multiple times. I think people need to understand that, the U5 language that they put on there, it's not in your best interest to give you the best likelihood of finding a new phone. It's very much in the company's best interest. And like you said before, there's a lot of ways to say the same thing. And with working with an attorney, you could potentially lighten up that language. And it could be the difference between you finding another top tier firm versus not. And I've seen that happen many, many times.
Right. And then the other angle on that, Corey, is depending on what goes on the U5, it may or may not, FINRA may elect to copy and paste that termination explanation onto the advisor's publicly available broker check form. So then it's not just the industry folks who can see it, but their clients or prospective clients, and that's going to follow you around like an albatross. And so when that occurs, we also help clients with filing what's called a broker comment form, where the advisor can put in a rebuttal on their broker check form to give their side of the story. So you can't get it removed from broker check, but at least clients and prospective clients can see, okay, well, this is what the firm said, and here's the advisor's explanation of what actually happened here, and you can sort of soften the blow, and hopefully advisors will prevent clients from being scared off by that entry.
What big mistakes have you seen financial advisors make through this process that like potentially, be damaging to them that they should know like absolutely not to do?
I would say the first and foremost thing is lying to the firm. I've seen advisors who had minor infractions that might have been able to stay at the firm, but then they lied about it. And then the firm's like, well, now we have to terminate you because we don't trust you.
Yeah.
So, but really the number one thing is not letting things fester, right? I mean, I use the phrase regulatory gangrene, right? If you let an infection, this kind of an investigation is like an infection. And if you let it sit and you don't treat it, it's just going to get worse. You want to get in there with some antibiotics, whether it's me or some other lawyer, to try to, tamp down the infection and maybe solve things. So I can be much more effective getting involved early on in the process than when somebody comes to me already fired and the U5 has already been filed. There's not much I can do other than help them if the U5 filing then triggers a FINRA investigation. So it's a little bit of money spent upfront goes a long way in getting the benefit.
That's awesome to know. I appreciate it. I mean, it makes total sense. As soon as a financial advisor reaches out to me, one of my first recommendations to them is to reach out to an attorney. The quicker they do, the better the outcome, in my opinion.
And I'd say the same thing goes on my end. Is that when an advisor comes to me and they've got a regulatory issue, I think the first thing I tell them is that they need to start looking for another job, right? So that if they need to go somewhere quickly, they can, right? The joke I sometimes make is, if you're about to get thrown out of the house by your wife, you better find an apartment to live in and have it ready to go just in case.
Without a
So
doubt.
you might not have to use it, right? But the last thing you want to do is be caught flat-footed, being terminated, and with no plan B as to a place to set up shop and bring your clients.
Yeah, and just as just talking about recruiting consultants, we could provide a lot of value to any financial advisor, considering making a move to another firm, but especially with termed advisors, the typical due diligence process to find the ideal firm for you typically takes anywhere from 4 to 6 months of pretty solid time investment. You're doing a crash course when you are, getting terminated from your firm. You have 30 days for your U5 language to come out. You're kind of on the sidelines for that time. And depending on the firm that you're at, there are people at that firm that are calling your clients during that time and trying to retain your business. So not only do you need to find a firm that's a good fit really, really fast. So there's a couple different ways that we can help. Number one, it's just helping you find a qualified attorney. We know multiple attorneys out there that don't just do this on a part-time basis. They do this all day, every day, have relationships with a lot of the legal teams inside of these broker dealers as well. And it just really help as we discuss. Number two, it's just helping you save a lot of time and stress during the transition. There's thousands of different firms out there. Once firms find out that you are, terminated, you're going to be getting a lot of phone calls. All the firms are going to tell you they're the best fit for your business. We could sit down with you, just help you understand what's important to your business, what your goals are, what your practice looks like, and align you with the right firms that are not only going to be, the best fit going forward in the future, but are also going to, accept your potential U5 language. Each firm out there has different policies for in terms of number one, if they accept terminated advisors and what their threshold for U5 language is, when something like this happens. So we can save you 10, 20, 30 hours of time alone, just, vetting it out, going directly to the compliance companies of these firms and saying, hey, are you going to be comfortable with an advisor that's in this situation, instead of you barking up barking up a tree that's not even going to accept you in the first place?
Yeah, Corey, you raise a good point there because sometimes I get involved when advisors are sort of in the later rounds of the hiring process and they've had a negative U5 entry. I will sometimes be asked, especially firms where I do business with those people and they know me and they trust me. I'll sometimes get on the phone with compliance personnel or people in the legal department, and they'll want to hear from me what my read on the advisor situation is and sort of ask for me to vouch for them. So, or sometimes I'll help an advisor. They want a letter of explanation from the advisor in their own words about what happened. And of course, it's not going to be in their own words. I'm writing it for them. And the firm knows that, wink, wink, nudge, nudge, but helping people put the best spin on a bad situation. So that's another area where I can definitely add value in a termination situation.
Sure. And just two other pieces of information that I would plead for financial advisors to do. Number one, just once a year, even if you don't think something like this will ever happen to you, print out a copy of your trailing 12 production report and your assets under management report. Firms are going to be so much more comfortable accepting you and giving you an offer if they understand what your practice looks like, if it's a good philosophical fit, versus just an advisor telling a firm what their practice looks like. It's going to give them so much more comfort. It's just one thing a year that's going to set you up for success if something like this ever happens in the long run. And also, as well, a big part of the coaching process when something like this happens, you want to have conversations. You don't have to have conversations with 20 different firms, but have conversations with, some top tier firms, which are like your reach schools, the firms that you really, really want to go to. And then also, have a few backups that are kind of backup schools that if you don't get into your, the main college that you want, you still have some options out there. I can't tell you how many times I've seen financial advisors. They really want to go to one firm. They put all their time and effort into that one firm, and it comes all the way down to the end. And the firm will say, I'm sorry, we can't move forward because of what your U5 language is. Then this financial advisor has to start the due diligence process all over again when he could have been doing, 5 or 6 in parallel and had multiple options to get back to serving their clients as quickly as possible.
That's a really good piece of advice. No, that's great. The other thing we didn't really touch on too much, Corey, is, and I mentioned it briefly, but advisors need to also understand that depending on what the U5 says, this may also trigger a follow-on investigation from FINRA. And that's also why you need to be careful when you're dealing with what the U5 language is going to say. And also, what if you're going to do a broker comment form on broker check, making sure that whatever you say is consistent, that if you get an investigation notice from FINRA, it's called a Rule 8210 notice, where FINRA is asking you questions. Dear Joe Broker, we see you were recently terminated by XYZ firm. We have, please answer these 10 questions and give us all documents responsive to these 10 categories of documents, and you have 2 weeks to do it. And you want to be sure, if you've put in a broker comment form, that your story back to FINRA is going to be consistent with that. But also, that is absolutely, if you haven't hired a lawyer like me yet, that is absolutely the time to do it. I am constantly amazed by, at least once or twice a year, I get an advisor who calls me and is looking for help because they've already responded on their own to 1 or maybe even 2 information requests from FINRA that's now investigating them. And now they're really in trouble because FINRA has summoned them to show up for a deposition. And now they realize, well, geez, maybe I ought to get a lawyer. And sometimes I have to tell those people, there's really not much I can help you with here because you've already sort of set the story in stone. We can't change the narrative because you handled this yourself. It's shocking to me that somebody would ever an advisor would ever respond to an investigation notice from FINRA on their own. And as I say, if you haven't hired somebody yet, the minute you get a notice from FINRA of any sort after a termination, you need to hire qualified counsel who do this work regularly.
That's awesome, Scott. That's great advice. I really appreciate your time as always. You have so much value. If a financial advisor has legal questions, how do they get in touch with you?
Yeah, the easiest thing to do is to just Google Matasar Jacobs LLC in Cleveland, Ohio. We're the only firm in the country with that name, and my contact information is right on the site.
Awesome. Thank you so much. And if anyone has any questions about the broker dealer or RIA landscape, my contact information is all over my YouTube channel and my podcast. Thank you so much for your time, Scott. And I hope you have an awesome weekend.
My pleasure. Thanks, Corey.